Okay, let's get started. Had a good morning. My youngest of four children had his last kindergarten concert today, so it was bittersweet. So I'm still home, heading into the city right after this Zoom. Um, and I know we have a lot of real estate professionals. I guess just wanted to, before we get to the topic at hand, something as the market picks up, a little hack we've been using recently, due diligence hack. I'll make it quick, but I often find and realized recently that we might not get a deal sheet on a new deal for a few days until after the offer is accepted. Say the offer is accepted today, we might not get a deal sheet till tomorrow, Friday, or Monday. To expedite the transaction, I think it's highly recommended. It's so simple. Just send the buyer's attorney the address and the managing agent's information. Half the time we can find the managing agent's information ourselves, but we can get a head start on the deal, especially as the market picks up, right? There's going to be competition. I just got a deal. They want it signed in 5 days. The problem is managing agent can take 5 days to answer a questionnaire. So if we start on due diligence before the deal sheet comes out, it should hopefully impress the seller's broker to see that we're on top of our game. We have a due diligence department, so it's very easy for us to add another deal to the pipeline. Just keep that in mind, while being proactive. And another quick announcement: we recently brought on a tax attorney, a tax controversy attorney. The simple example is the New York, resident that wants to move to Florida and not get dinged for taxes in New York. It's actually a lot more complicated and comprehensive process than I had realized. And it's good to be proactive and get ahead. So we have a webinar next Tuesday. If you want to join, send me an email. We're also doing some other webinars about just IRS tax concepts. A lot of small business owners deal with sales tax, or they don't deal with it and they get hit with huge penalties and fines. So we're excited to expand. We saw a big need from our existing clients in this area. But getting to the topic at hand. So for years, as long as I've been practicing, right, sellers would always give a $500 credit instead of filling out the property condition disclosure report forever and ever. I think most sellers and brokers didn't even know you had to fill out the form, and that the $500 was an option. It was just done. It was all part of our contracts. But as of March 20th, next week, the $500 option is no longer a form, and sellers have to fill out the form. Now, very important, some bullet points. And I'm going to send an email to everybody with a summary I've put together. I've presented on this a bunch of times now, so I've cut down the summary pretty tight. I'll send you the new property condition disclosure form as well. So, you can certainly listen. Don't feel like you have to write down all of the notes. I have a nice little tight information email for everybody. Number one, very important. This only applies to 1 to 4 family homes, right? It does not apply to co-ops or condos. It does not apply to co-ops or condos that are 3 units, right? 1 to 4 family homes. This is New York State. Some other, very practical information. This applies, most other states in the country already have this. New York is kind of new to this. I know there's some brokers that work in Connecticut. Some states, it's so common, even like the outer boroughs, the outer portions of Brooklyn, it's so common that this disclosure is filled out and completed by a lot of sellers and left at open houses for the buyers to take if they want to take it. So anytime there's a change in law, there's a transition period, right? For everybody to get comfortable with it. I think this transition period hopefully will be short, a few months. There's definitely, I'm going to chat with a bunch of lawyers, figuring out how we need to handle it from our end. But this is more focused on the brokerage community. How do we explain this to our clients? What's the premise behind this? Why did they change the law? It's all about health and safety, right? If we remember the horrible accident in Florida, Surfside, where the building collapsed, since then, and I know we have some bankers on the line, banks have started taking a look at issues relating to health and safety on buildings, co-ops, condos, and townhouses. Just for an example, back in the day or forever, banks really wouldn't worry too much about local law 11. That's when you inspect the facade of the building. You see all the scaffolding around the city. When you inspect the facade, they want to make sure there's no loose bricks, no pointing issues. So anything relating to windows, health, deferred maintenance, assessments that have been going on for a long time, banks are worried about that. Similarly, townhouses, the government, New York State is now cracking down and making sure that these properties aren't unsafe. Think about all of the rain we had last year, right? We had an unprecedented amount of rain that leads to leaks and mold and other issues. So, as of March 20th, next week, any contract signed after March 20th, this form has to be provided to the buyer before they sign a contract. So for all of you agents that have exclusives right now, right, 1 to 4 family homes, the deals aren't in contract, you need to speak to your clients about this. This is very important as well, and this should hopefully give the sellers some comfort level. The standard is actual knowledge, and this takes me back to law school, right? Actual versus constructive. Actual knowledge means what you actually know. There's no duty to investigate. Now, listen, this has to play out, and maybe a proactive broker and a proactive seller or a sensitive seller investigates and wants to get all the information possible because they don't want any possibility of an issue down the line. So it's what the seller knows, and we'll get into sellers that live in the property now and absentee owners, right? A good question that just popped into the chat, and please, 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 I welcome all your questions. It does not apply to mixed use properties. And I'll get into other properties it does not apply to. So the idea is, and you as the savvy broker are going to figure out when you want to bring this up. Say broker A doesn't bring it up, right? There's competition to get the exclusive. Broker A doesn't bring it up. Broker B brings it up. And it's another form, and it has to be handled. I think some sellers, if a broker doesn't bring it up, and it's not your main pitch, it's not part of your main pitch, but it's for informational purposes. Some sellers want to know about this, right? Some sellers want to have all the information when they're evaluating what broker to work with. I wouldn't, make it overemphasize it, but simply say that, hey, this is a form that has to be filled out. I'll work with you. We can loop in an attorney to assist us. And it's something that has to be provided. New York State, wants to make sure that there aren't dangerous conditions that the buyer doesn't know about. Now, very important, I just want to clarify something I just said. Your seller, this is the most important part of probably the whole presentation. The seller must complete this. I'll repeat it. The seller completes it. You as the broker do not complete it. I don't care if your client is in the south of France on vacation. We want the seller to complete it because we don't want any liability. You don't want any liability. We're not completing it on behalf of the seller, right? The seller has to complete it and sign off on it. Now, I imagine at some point it'll be on Adobe, right, where they can just DocuSign and fill out the form. And I'll send you the form. Take a look at it. It's kind of what you would expect, right? Any mold, issues that relate to the facade, leaks, radon or oil issues. So, and there's always a legal concept to these things and also a practical concept, right? So you as an exclusive broker, and you know better than I do, right? I've never pitched an exclusive. Some brokers won't bring it up, which is fine. Some other brokers may bring it up when they're pitching the exclusive. At minimum, once you have the exclusive, right, you have to speak to your client about it because, there's different strategies. I wouldn't say strategies, there's different ways of handling it, right? It may actually, it's funny, incentivize sellers to take care of issues, while they're marketing the property. Maybe the seller knows of a few issues, right? And they want to say, hey, listen, the market's not great right now, right? Let's take care of these issues. So when I fill out the form, the issues are resolved. You can get the form today and fill it out in a month after issues are taken care of, right? It's all about what happens or what the condition of the house is at the time you fill out the form. Now, this isn't something to be cute about, right? say, for example, you fill out the form, right, today, and you don't have a buyer, you're not signing a contract for 2 months, and an issue comes up 2 months down the line, you should amend the form to include the issue that came up, right? A leak came up, right? You should add that. Um, so the idea, just I know we have some people kind of joining now. Number one, it's all about the seller's actual knowledge, what they know, not what they should know. There's not a duty to investigate. But if I'm a seller, you know, I'm going to make sure the form is filled out accurately. Um, you, as a broker, do not fill out the form. The seller should fill out the form, right? You can assist. I think you're going to end up looping on the attorney a lot earlier in the process than you normally would. Normally, right, you pitch an exclusive, I'm not involved. You know, when you think you're about to have an offer, then you loop on the attorney. You may want to loop us in earlier because it is a legal form and we can help the seller. It's just fear of the unknown, right? The seller, it's very straightforward. Again, I highly encourage you to read it and look at it. Some sellers are super involved, some sellers aren't. Now, the question that comes up, interesting question, is somebody who lives there full time, right? They know the condition of their house. They should, hopefully, right? I know in my house, I'm in the suburbs. When it rains really, really bad, there's a little leak. You want to describe it, leak. A little bit of, I guess it's a leak, running water coming down the fireplace. That's a leak, even if it's small, right? The banister is broken, in a townhouse. That has to be disclosed. So the question is, somebody who lives in a property full time, right, and knows about these issues, as opposed to somebody who's an absentee owner, right? Now, if you read the form, which again, I highly encourage you to, the buyer is still encouraged to do their own inspection, right? And everybody's worried about lawsuits, right? When we ever have a new law and legal forms. I mean, I'm not a litigator, just to be very clear, right? I'm not a litigator. But if you fill out the form, right, and you live there and you provide the information, it's hard to say that, something wasn't disclosed properly. Of course, there are going to be circumstances. And your client, I think, the old adage, do the right thing, right? Be transparent. For us as professionals guiding our clients, you have to just be very straight and direct. And, if there's a leak and there's a scale, 10 is the worst and one is, a minor leak, a leak is a leak, right? There's no like, this isn't supposed to be cute. We're not massaging things. So, and listen, there are going to be circumstances where your clients are not honest, right? They misrepresent, and it's going to be uncomfortable for you. And I encourage you to speak to your managers about how to handle that, right? If you know about something and they lie about it, you obviously, I always say clients are your best friends until they're not, right? So hopefully those circumstances are few, but there's going to be uncomfortable situations. I think just like the dual agency, right? Just like the new circumstances with your commissions. Unfortunately, it's something else adding to the pile that you have to deal with. I think I would highly suggest that you role play with each other. Speak about how your clients. It's gonna when it's easy, it's easy. When your client, not to say this is gonna be difficult, but your clients are gonna. Some clients we all know ask a million questions, and they're allowed to. They're entitled to, but it's fear of the unknown. They're nervous, so you want to get comfortable. And there's no issue. There's no issue with looping on the attorney to help you, right? But also, even for us, some clients are going to be cute, so we have to be guided by. And the form again, some of the situations don't even apply, and they're yes no answers. I'm just looking at some of the questions while we're chatting. What is the risk of the seller if they don't properly fill out the form? So there's, again, I'm not a litigator, but there's lawsuits. There's misrepresentation, right? So, and different types of misrepresentation have different statute of limitations, meaning a buyer can essentially bring a cause of action depending on, or a lawsuit, I'm sorry, buyer can bring a lawsuit depending on the cause of action up to 3 or 6 years after the sale. Now, I imagine those lawsuits aren't going to be so common, but they can do it, right? They can bring an action. What's very interesting? A lot of our townhouse deals, this is something to think about, are typically as is deals, right? A lot of clients have the misconception as to what as is means. As is means if something's broken now, it doesn't have to be repaired. Just, touching on co-ops and condos very quickly, because it's a good analogy, a good to differentiate the two. A lot of people have the misconception, and it's a misconception, that all co-op condo deals are as is. Co-op condo deals, 90% of them are not as is. Sure, the walls and the floors, the surfaces are delivered in as is condition, but the major systems, the heating, the plumbing, the appliances, the boilerplate contract says those systems are delivered in working order. Historically, townhouse deals are as is. Now, this disclosure, it's not part of the contract, but it kind of takes those townhouse deals away from being, it could be as is, but the information is still disclosed. So now the buyer, and this is, first of all, think about like the practical part of it. This is the whole purpose, is for the buyer to be aware. There's a Latin term called caveat emptor, right? That means that the buyer has to figure things out on their own. No longer are these townhouse deals, because of the new disclosure, caveat emptor. Instead of buyer beware, the seller has to disclose. So there's a clear shift. And the reason being, we want to protect the consumer. Not to sound morbid, but we don't want homes collapsing on people, right? Just to be very blunt and very clear with our clients, there is a good reason behind this. And our city, our state, our government right now is very hung up on health and safety for good reasons, obviously. So I'm looking at, yeah, there's definitely, it can bring a cause of action or a lawsuit if it's not filled out properly. It cannot be waived. Somebody asked me, I gave a presentation, what happens if we offer $10,000? That would be, helping the wealthy out, and as opposed to, people that couldn't afford to give a higher amount. Yeah, I do not. It's my understanding this cannot be waived. Also, just to preface this, I am an attorney, and I'm going to sound like an attorney. These things evolve, right? When you have a change in law, sometimes there's interpretation that takes a little while, right? If you go, again, we're not litigators, but if you go in front of a judge, right, there's a new law. That's how the law gets interpreted. Once there's a lawsuit or many lawsuits, the judges have the lawsuits, I'm sorry, create case law, which gives lawyers a kind of a vision or clear idea as to how a law is being played out and interpreted by the courts. The goal is that this doesn't, reach, courts and lawsuits, but of course, inevitably it will, hopefully in a minimal way. So Marcia asked a good question. What happens if you know about a misrepresentation? Number one, I'd speak to your manager. I hate to say, but I think you need to protect yourself and send an email. And because you don't want, what happens with lawsuits is, they sue everybody, right? The buyer sues the seller, and the seller brings you in, right? I always say like I said, clients are your friends until they're not. So what happens if they bring you in and the seller says, you knew about this, you guided me towards this, and an email can protect you against that, right? So it's sensitive. Obviously, clients, are referral sources. They, help you and of all of us make money, but you have a license just like I do, right? And you don't want to put your license on the line for any deal, right? It's your career. So the form, somebody asked, what's an attorney's obligation? And that's still being played out too. But basically the form has to be provided to the buyer before the contract signed. So we are having meetings at my firm. What we're going to do, it now becomes our responsibility just as much as yours. We need to make sure that the buyer's attorney confirms that the buyer received the form before the contract sent out, before the fully executed contract sent out, right? It's pretty simple, right? We need confirmation that the buyer has this form completed before the contract signed. The new form just came out, so I'll send that to everybody as well. But I want you to, Kay asks, this is a great question. What happens if the seller doesn't know? The answer is it's what they know. It's not what they don't know. So they don't have a duty to investigate. It's if they know something, if they don't know something but should know it, they don't have to disclose it. That being said, right, if you live in a property full time, right, you've been living there for 5, 10 years, there is a lawsuit. It's hard to say that you don't know about something. Another idea to think about, and you can brainstorm with your colleagues. If you're an absentee owner, some absentee owners may want to do an inspection on their own just so they can learn about the property. The issue that comes up there, now, once you do the inspection, you know about all the conditions and you have to disclose them. But on the flip side, again, just I'm thinking about out loud, right? Sometimes there's no perfect answers. You want to protect yourself, right? So if I'm a seller, I fill out the form to the best of my ability, I do an inspection, I give you all the information. How does a buyer come back and say something wasn't disclosed, right? You've done, everything you can. So a few people are asking, and I'll get to it. There are exceptions. This does not apply to estate deals, which is great, right? It does not apply to intra-family transfers. It does not apply to foreclosure actions. So that helps a little bit, right? I'm looking at these questions. They're coming in fast and furious. So why doesn't the form get reviewed by the sellers? I think a lot of situations it will get reviewed by us, but right now it doesn't say, the form doesn't say it has to be reviewed by seller's counsel. I think it's up to you. If you're not comfortable or your client's not comfortable, they should loop in the attorney, right? I said initially, I know some of you joined later on, that as a seller's attorney, we usually get introduced to the deal when you have an offer or you're about to have an offer. I think inevitably on townhouse deals, purchase side and sales side, we're going to get introduced earlier. There's no reason why we can't work together to give the seller a comfort level and figure out. There's different strategies, right? There's different strategies here. Like I said before, in a hot market, you fill out the disclosure and you tell the buyer, listen, I have 5 offers, we're not repairing anything. In a bad market, right, or a market where there aren't too many offers, maybe the seller says, whoa, I don't want to fill this out. I know these 3 issues. I can repair them on my own for a few $1,000s. Let's fix these issues. Then I'll fill out the form and it's clean. Also, something for you as brokers to think about. What happens when a buyer's broker comes to your open house and asks for the form before they put in an offer, right? It's going to happen, right? Buyers are going to say they know this exists, and there's a strategy behind it. A lot of this is strategic, and a lot of this is, as a seller's broker, it's hard to say no, right? Because that makes people uncomfortable. So you have to think about that. In some situations, you're going to send it to them, send it to the buyer, when the attorneys are involved. In some situations, they're going to ask you for it at the open house. So the world of real estate, no 2 deals are the same, right? No 2, negotiations are the same. So we have to, just be on our toes and educate the seller. I think a lot of it is just educating the seller, being proactive, giving them a comfort level that hey, this is going to come up. Listen, if it's easy, right? It's a clean, even if there are quote unquote issues with the property. But I think what's going to happen over time, it's going to be so common where the disclosure may be at open houses, right? Just like it exists in other states. I know it exists in Connecticut. I imagine, right? I don't have a crystal ball, but if someone asks for disclosure and you don't provide it, they're going to get nervous about it. You have to have a good answer. You can say, listen, I have a deal right now, actually, where it's a co-op, but the idea is the same. There are issues, right? There's an issue. There's a leak, right? And they haven't fixed the leak yet, and they are going to let anybody that puts an offer in know about the leak because they don't want the buyer coming back and renegotiating, and they're going to take care of the leak prior to closing. So they're just, you have to get ahead of it. And I think number one, transparency is important with your clients, obviously. You want to be strategic and figure out how you need to have the discussion with your clients. Yep, co-ops and condos are exempt. Estate sales are exempt. The actual reading is orders of probate, during administration hearings. So again, I imagine all estate deals are exempt, but we'll have to, really get granular on some deals. attached to the contract. I imagine over time it may be just like a lead paint affidavit. I don't know if that's clear yet. All I really care about is that it's provided, before. And I might, I have to really think through it. We're having actually a meeting with our partners on Monday. Do we need an acknowledgement from the buyer? An acknowledgement from the buyer's attorney should be fine, right? Um, what if sellers receive buyer's inspection? Do they now have to disclose all the issues? That's an interesting question. That's a very interesting question. I guess if the seller knows about the issues and they see them and they look in the apartment, I guess, well, you know what? Again, let's like, it's easy to get caught up in like, what if this, what if that? If we stick to the basic idea of being transparent and filling out the form. So let's say the seller didn't know about something, right? And now the buyer's inspection report discovers an issue that they didn't know about. The buyer knows about it, right? So you update the report and you fill it out. I mean, it's all there, right? And the whole idea here is disclosure. The whole idea is there's a concept of going in with your eyes wide open, right? This isn't like I gotcha. It shouldn't be an I gotcha situation on any side of the transaction. Um, Entity, yep, it's definitely applicable to entities just as much as individuals. Investors, don't get, a freebie here. Um, So just looking, I want to make sure I covered all my notes here. There's this isn't like an overly involved presentation, right? The whole idea of it is to keep it simple. I think the complexities will come into place, when people are asking for them, when the sellers decide how they want to handle it with regard to repairs, understanding that being very clear to your clients that this is a legal form. This was signed off by the governor, right? This is a New York State legal form. So we have to be open and honest. There's definitely strategies. And when I say strategies, not strategies to get around the form, but strategies as to how to handle issues as they come up. I definitely recommend getting ahead of it. And think about, and I'd speak to your manager and speak to your colleagues. Is it, I'll give an analogy, right? If you refer me a client, right, and it's sales, right, it's a sales tactic. I, want to stay in touch with them, right? So I will offer to send them a closing cost estimate because many brokers, I love all of you. You help support me and my family. Send general closing cost estimates, right? And first of all, you should never, just as an aside, draft closing cost estimates because if you mess up a number, clients, will, come after you. Um, I offer as a follow up, right? Sales is all about following up to send them a specific closing cost estimate for their transaction right? So the idea is the analogy here is if you're going to pitch an exclusive and you don't speak about something that exists and it's a new law and somebody else talks about it, if I was a seller, I'd be curious, well, why didn't the first broker I spoke with, even mention it, right? And you may say, Andrew, listen, and again, I've never pitched an exclusive. You may say, Andrew, like less is more now. There's no reason to get into it. And that's a strategy, right? So there's no right or wrong answer. The $500 penalty, yeah, it's not a penalty. So the idea was you can give a $500 credit instead of filling out the form. You have to fill out the form now. No longer is the option of the $500 credit even on the table. What is your opinion on the completed form held by a listing agent or to go directly to the attorney supplies it? I think in many situations, you and the seller will fill it out and it'll be fine and you'll provide it to the buyer. I think if you have a super nervous seller or you're not sure how to answer a question, then you're going to loop into the attorneys. I think with many deals, we won't even be involved in filling out the form. I think in the beginning, until you get comfortable, it's great to have an attorney looped in just to go through it with everybody. But we're going to sit on the phone and do the same thing you do, right? And if they say they're not sure, you're attesting to this. It's it's a legal form that you're saying is open and honest. Um, so Sal, yeah, I guess I can't imagine that you can waive this. All the attorneys I've spoken to, we don't see any option to waive it, even if something doesn't prohibit it, doesn't say you can. But listen, not to buffer that. As this plays out, you know, perhaps there is a waiver option, but right now we don't see one. Um, for a short sale situation, yeah, I guess the question is, does that fall under? It's a short sale is not a foreclosure, right? So we're gonna have to err on the side of caution initially, right? If something doesn't fall, and I'll send you the exemptions. If something doesn't fall under a clear exemption, I hate to say, as a lawyer, we're gonna have to err on the side of caution, right? We have to just be a little careful until we really get a clear answer. Um, yeah, that's interesting, Lucy. In other states, so and again, in other states, this is very common. Lucy is saying in other states it's loaded into the MLS system, so it's there, right? Um, so I think it's going to be it's first of all it goes both ways, just like anything else. If the property's clean, it's a nice selling point. If the property has one issue, you know, now you may say, listen, we're not repairing it, but it's baked into the deal. As a buyer's attorney, this is interesting also to think about. I would rather, you know, as long as the buyer's okay with it, take a credit, you know, for repairs as opposed to a seller doing it because you assume, unfortunately, you have to assume that if a seller makes repairs, they're going to do it on the cheap, right? They're just going to get it done. They're not going to hire the best person. They're not going to put in the best, you know, mechanical system. Unfortunately, I think it's a fair assumption. And just while we're talking about inspections, I always, and this is very important also for townhouses where, you know, every buyer in a townhouse should do an inspection. As a lawyer, I tell clients an inspection is typically not a means to renegotiate unless there's something materially wrong with the property. First, we tell clients, of course, you should do inspections. We should be super proactive with inspections, get them done as soon as possible, as soon as the offer is accepted, because you don't want an inspection delaying the deal. I tell clients that they should be there in a perfect world for an inspection or be on FaceTime because you read an inspection report, you know, the inspectors have to protect themselves. So they're going to tell you every little thing that's wrong with the house, things that the seller may not know about or think are issues, right? Because again, they have to protect themselves. And I tell buyers, be there at the inspection because first of all, you get again a practical idea as to what's involved. On the inspection report, the inspector may make something seem like a big issue, but it's not a big issue, right? Because you were there. The inspector, for example, says the water pressure is poor, but you were there and you saw the water pressure is perfectly fine. So it's stronger than your current apartment, right? So you're there for the inspection. You can ask a lot of questions. You can get educated, and you get a realistic idea of what's going on. You still get a written report. A lot of buyers, frankly, don't even like, you know, read the written report in detail. But even when you, of course, I recommend it, but when you get the written report, I always tell the clients before you read it, do me a favor and email the inspector and ask them what the red flags are, what the material issues are. You may have a 40-page inspection report and the inspector says there are no big issues, right? So it happens. It happens all the time. I also tell clients, listen, we're not shy. We'll renegotiate smaller issues, but it's not the norm. You could kill a deal because you're negotiating, you know, small issues and the seller doesn't want to hear of it. But on the flip side, obviously, if there are material issues, you may go back and try to negotiate, and the seller may say, sure, we'll give you credit. Or they may say, no, we have 10 offers behind you. Thanks, but no thanks. Um, so look at some of these questions. So inspections are always, you know, important, right? And it also plays into the deal because there's no, you know, with townhouses, the buyer is going to most likely figure out any issues that are present, whether it's by the seller or by the inspector. So there's no, you're not hiding anything, whether intentionally or unintentionally. Um, should you present to buyer when showing if it's your exclusive, or should you wait to get the owner's permission? What if buyers want things that are wrong fixed? Yeah, no. So I think you have to have a conversation with your seller, a strategic conversation. What I think is going to happen is, I mean, if you are a buyer's broker walking into a townhouse in a week, wouldn't you ask for it right off the bat? I mean, I think that's what's going to happen, right? You're going to have to, and the seller may say, listen, we're filling it out, but we're repairing these two items, or we're filling it out. These two items exist, and we're not giving a credit, right? It's part of our listing price. It's baked into the deal. So that's what's going to happen, right? You can still sell your house as is, right? You can say these are the issues. We're not repairing them, but you still have to disclose them with the condition, the property disclosure report. So that's really, you know, I think the big ticket items. I will send, a nice little outline. I hope it helps. But certainly stay in touch. This is hopefully it's not going to evolve too much, right? Hopefully we have, I think we do really have a pretty clear path as to what's involved. Don't be intimidated by it. I feel bad, for the brokerage community, because it's another form, right? It's something else that has to be done. But think about the positive of this, right? It's going to, not to sound hokey, but hopefully save lives, right? That's the purpose of this, to, prevent injuries and death, right? So if we're all kind of doing our civic duty, that's a great piece. And just before I wrap up, I wanted, we're a sponsor of NIRAC, which kind of dovetailing with the presentation. It's all about educating the real estate community, all about, bringing transparency. And the real estate industry, has a big giant flashlight on it right now. So if you haven't heard about NIRAC, I definitely encourage you to check out the website if you're interested in joining. We do a lot of these types of presentations. There's other lawyers, other bankers involved, real estate professionals. So it's a great way to learn about, timely information, as well as, information that's, kind of a staple in our community. You have specifically disclosed each item. No, you'll see, take a look at the disclosure. It's very specific. It breaks down different areas that you have to disclose. There is an option, there are a lot of yes, there's an option for yes, no, or I don't know, or I'm sorry, yes, no, or not applicable. Thank you, Anna. Anna just put on the link for NIRAC. And if you have any questions about NIRAC, you can definitely reach out to me separately. I think in this age, everybody's emphasizing community, and a lot of you as independent agents, right? Well, you're independent contractors. You're coming to the office, you work from home, and I think what NIRAC brings, or I know what NIRAC brings, is a sense of community and collaboration and discussing items. It's very hard, right, to talk about this. Like after this conversation, I would hope each of you gets together, at your office or speaks to each other about, like, I'm not a broker, right? So I have a good idea as to how it plays out, but you may have, practical situations you deal with. So NIRAC provides, an area where you can learn about different, concepts and laws and issues facing the brokerage community, and kind of work towards solutions together. But I want to thank everybody for joining. I want to be respectful of everybody's time. And you'll get a follow-up email from me and my team. And have a great day. Enjoy the weather. Thanks all.